Hello, welcome everybody. My name is Edward Mead. I'm a solicitor at Sterling Law. Today we're joined with the partner of Sterling Law and head of immigration, Mr. Ruslan and also the marketing manager, Anastasia Nede, who will be answering and providing us questions at the end. So yes, we at Sterling Law are a leading Legal 500 immigration law firm, and what we'll be discussing today will be the UK's new immigration points system and what it means for businesses and individuals.
Yes, Edward, we're going to look at the key changes and dates businesses need to look out for and the guidance that's on offer to steer businesses and individuals through the process. And if you'd like more information after the webinar, please go to gov.uk hiring from the EU or sterling-law.co.uk. And it's my pleasure to host this discussion about the changes to the immigration system, which came into effect on January the 1st. We'll cover what's changing and how it affects businesses. And I'm going to start with you, Edward. If you could just outline for us this new immigration system and the government introduced in January, how it will affect the business and how it transforms the immigration system.
Yes, thank you, Ruslan. Some big changes have come into force for the UK immigration system. Since the 1st of January 2021, free movement with the European Union has ended, and the UK has introduced a new points-based immigration system. And the big change that goes alongside that is that EU nationals will be brought under the same immigration system as the rest of the world. So why is that such a big change? Is at the moment, under the previous free movement rules, EU nationals were able to move to the UK and look for any type of work, any type of wage level, whereas under the new points-based system, anyone coming to the UK from anywhere in the world from the 1st of January 2021 onwards must apply for a visa and meet a specific set of requirements for which they must score some points.
So why is it sorry, Edward, yes.
Sure, sorry, Richard. So yes, in most cases, people coming to the UK will need a job offer from an employer who has already been sponsored by the Home Office as part of the new points-based system, and then visas will be awarded to those applicants who obtain enough points. So this is quite a big change for employers who recruit EU nationals from outside the UK who will need to adapt to this change, but it'll also be important for new employers who wish to recruit non-EU nationals from around the world, because they should find the new immigration system far more flexible and simpler than the previous system for non-EU migrants.
And the Home Office claims this is a skills-based immigration system. This is all about really putting it into the hands of the employers in terms of who they want to bring to the UK to fulfill particular jobs. And it's very much focused on really how trying to provide routes to the UK for the kind of skills and talents that the UK needs as a country to really complement the current workforce and really move away from this big difference between immigration systems, between EU and non-EU nationals, and to ensure that we have a system where it's in fact neutral to where people from around the world are coming from.
Yes, absolutely correct. The UK government believes that the new UK skilled immigration system will be amongst the best in the world. It will be more certain than the US or the Canadian system, and to some extent be similar to that of the Australian system. So it should be far more efficient, far quicker than most, and I believe only Singapore will routinely issue visas as quickly as the UK could. But there's a lot of the employees need to be ready for and how it will affect their business.
So Edward, can you just tell us who is affected and who is not affected?
Yes, that's a crucial point, one to clarify. So we're talking very much about a new system for people who move to the UK from the 1st of January 2021 onwards. So those EU citizens which were previously and currently resident in the UK are protected under the withdrawal agreement with the EU, so they can continue to live and work in the United Kingdom as they do now. The important part is that they must hold status under the EU settlement scheme. So please do note that if you are an EU national, you do have until the 30th of June 2021. And at that point, the grace period will end. So it's imperative that those EU nationals that haven't applied for pre-settled or settled status must do so now. I believe there's been about 4 million applicants already into the EU settlement scheme. And what's also to note, importantly, is that Irish nationals will not be affected as they are protected under the current common travel area agreement. So their rights will be protected in UK law, and they will have in effect the same rights as British citizens would do here in the UK.
Thank you very much, Edward. And how will things be different for employers from the way they currently recruit staff from abroad?
So if you're employed that regularly recruits from outside of Europe right now, you're going to find a system that's a little bit more expensive than it has been, but far quicker and more streamlined, more straightforward than what we previously have. So that's a major improvement. However, if you typically recruit from Europe, whereas up until the 31st of December 2020, free movement, and you could offer EU national a job offer on a Friday, and they'd be able to start work on a Monday. There's going to be a lot more complications and extra steps. So you'll need to be thinking about whether or not the person will qualify for the job that they're going to do the work for. You need to be wary of the salary level which they're paid, and then also you'd have to take into account the Home Office and government fees for the application, and ensuring that the company has the valid responsibilities in place for sponsor license requirements. So without free movement, it's certainly going to be more complicated for employees and for companies going forward.
How will this new system significantly impact recruitment plans for businesses?
So the system will add a considerable amount of time and additional work for small business employers. So they'll need to factor in the terms of their employment plans, how long it would take to onboard someone and bring them in to ensure they're meeting all of the necessary criteria and checks that the Home Office has outlined. So that will be quite a change for many small businesses, but Sterling Law has in-depth expertise in dealing with this area and would be happy to provide assistance to prospective businesses and their employees going forward to make the process as easy as possible.
I think it would be very useful if you could just highlight some of these changes. What is the salary and skills threshold for recruiting talent from abroad?
Sure, so I'll try and be quite as brief as I can with this, because there are various requirements, but to break it down in a way, there's 5 criteria for recruiting from abroad, including now from EU countries. So firstly, migrants must have a job offer. Secondly, they'll need to meet the criminality threshold, so they can't have any criminal convictions. Thirdly, they'll also need to speak English to an intermediate standard. And then the final 2 criteria which need to be met are those of skills and salary. So the skill level of the role has to be equivalent to RQF level 3, and the salary also has to meet the minimum of 25,600 or the going rate for that job. So it does differ depending on each job role, so we have to then tailor it according to both the company and the employee's needs. So I think that's a crucial point, is to get in touch, and we can then correctly advise and state what the company would need to do going forward for the prospective employee.
Thank you, Edward. In a nutshell, are all businesses eligible to become sponsors?
Effectively, pretty much, provided they haven't broken any of the UK immigration rules previously, they're a genuine business, they aren't dormant, and haven't engaged in any criminal activity, then broadly, yes.
Thank you. And what does this new system mean in terms of recruiting globally? Are there benefits? Are there any challenges?
I'd say definitely more benefits than the previous system. I think businesses, certainly those that have had experience of the previous sponsor license rules, would find the process far more straightforward. Right now, if I was advising a client on onboarding a worker here who'd want to stay permanently, previously it would have been taken 3 or 4 months, but with the new system, it is far more efficient, so that can usually be increased by a month. Obviously with COVID, that is subject to certain changes given the delays at the Home Office, but it's also possible under the new system to switch and vary your leave between work categories, which wasn't possible in the past. So a big benefit would be, say, switching from a tier 5 visa to a tier 2, which Previously, you would be unable to do so, but now individuals are able to. I think that'd be a real benefit, and there'd be a lot of applicants who'd be eligible to apply and switch into the skilled worker route.
Thank you, Edward. I think, understandably, businesses have had to focus a great deal on this pandemic, COVID-19, this year. You've already outlined why it's important to focus on this new immigration system. And I think, just briefly, if you could just add, how will it significantly impact recruitment plans? And so just kind of talk us through the planning side of it.
Yes, so regarding the recruitment and also about retention, on the recruitment side, whereas now if my client needed to recruit somebody in February to come and work in their team and they were European, then as it stands at the moment, they would have had to have made a job offer, notice periods allowing when they could start work. But on the previous law, it was far more difficult. You had the resident labour market test, which you had to navigate and be compliant with. But from the beginning of January this year, individuals need to also hold permission to take the job, as long as they aren't from the UK or Ireland, in which case they'd be exempt. But getting that permission for the job requires a fair amount of legal assessment, which we can provide, making sure that the applicant is working within the right job occupation, they have the relevant experience, and also making sure they're paid enough and so on. So I think that's certainly where we need to take instructions from a client and a business and state to them definitively what we can do going forward. And then also we have to look into about paying the home office fees, because they can sometimes be quite sizable in itself. So I think that's an arrangement which an employer and employee would have to agree upon that going forward. But once the applicant obtains entry clearance or is in the United Kingdom with the skilled worker, then companies have to keep in mind their responsibilities as a sponsor license holder, making sure that their skilled worker is complying with the terms of their visa and abiding by that. So I think it's important to break down those new applicants that would be applying from the 1st of January 2021 onwards and those from previously. So if you are a European national and have been resident in the UK before the end of the transition period, it is crucial to apply to the EU settlement scheme before the grace period expires on the 30th of June 2021.
Thank you, Edward. Currently, businesses have a lot on their plate. So just kind of talk us through why it's so important for employers, especially I think with small businesses, who just have a lot happening, to focus on immigration system in terms of recruitment, in terms of retention of staff.
So yes, it's a very challenging time right now for small business and for small business employees. So they're grappling with the number of challenges in relation to COVID. But one thing is clear is that on average, around a quarter of small businesses employ at least one person who is an EU national. So small businesses who have an EU national within their workforce, it's definitely a component, and they need to make sure that employee holds settled status or pre-settled status, and right to work checks will come in as advised from the government from after the 30th of June 2021 onwards. So I believe companies should start performing their own due diligence at this stage to make sure that they are ready for that. Also, the real challenge is to ensure that businesses are aware of all of the new steps to take following the 1st of January in dealing with the COVID pandemic. So we at Sterling Law can advise companies and have great expertise in dealing with that. So please do feel free to reach out and get in touch with us, and we can then advise you accordingly.
That's right, yes. And could you just talk us through what businesses can expect over, say, the coming 5 years as a result of these changes?
Yes, so I think most businesses can expect that the current immigration system can be quite complex, for small businesses. So they don't recruit from outside of the EU. But I think with free movement ending, there will be seismic changes which companies will need to be aware of. So grappling and understanding with the new rules will be down to business owners themselves. And maybe unlike the settlement scheme, we know that the immigration rules can be quite complex and difficult to grasp. So for small business, I imagine that this will be a challenge which they'd need to navigate through and understand the Home Office rules, the guidance, etc. So I think it's important to note of business compliance, and that there can be quite severe financial sanctions on those companies which aren't compliant with that. So it's important that businesses have that support structure in place and guidance throughout, and this is effectively what we can provide, is that holding hand throughout the whole process to ensure that businesses meet their goals and are compliant with the new immigration rules.
Thank you very much, Edward. That's very helpful. So what has the Home Office done to minimize the burden on businesses? That's including small businesses and self-employed, because I suppose a big concern is whether small businesses might be put off by the fees and the registration time.
Yes, I mean, that's something which with sponsor license applications and subsequent skilled worker visas, they can be quite costly. So I mean, the Home Office, they have, to their credit, taken out some of the complexity from the sponsor license process. So one of the big burdens which they really removed, and this was quite off-putting to businesses I've spoken with before, was the resident labour market test. So it would be the requirement for businesses to advertise the role first in the UK and wait for, say, 28 days to identify if any eligible worker had applied. So in terms of the new system in place, the resident labour market test has been abolished, and so that's a real plus side, certainly for businesses. Also, the new system has lowered the salary threshold, which is definitely of a benefit to many small businesses, because they can then target individuals within a certain skill level, which previously they weren't eligible to do so. However, as you said, Ruslan, one of the biggest obstacles to overcome is the costs of the visa system. So it's likely for many small businesses won't be able to afford the current fees. But I think going forward, you can sort of see if your company has less than 50 employees, then you'll be charged £536 as a small business, and £1,476 if you hold sort of 50 members of staff or above. So those are sort of the fees involved.
Yes, and in a nutshell, again, Edward, what does it mean to be a Home Office registered sponsor? What does it allow employers to do, and how do businesses know whether or not they need to become a Home Office licensed sponsor?
So the concept of sponsorship is quite simple. An employer needs to check the eligibility to become a sponsor. In particular, there are some rules around criminal convictions and also any previous immigration offences. The sponsor will need to choose. The employer will need to choose what type of license they wish to apply for. So it depends on whether they want to bring in a general skilled worker or workers through the intra-company transfer route. They will need an employer basic concept behind sponsorship in the business is benefiting from bringing in the migrants to the UK to work, and there's also the responsibility to make sure that the visa holders are compliant with the terms of their visa. So once a sponsor has obtained sponsorship, they will then be able to bring in migrants, provided they fulfill the criteria as I've previously stated above, say basic skills level, salary level, and a need to hold intermediate English. So I think we'll bring in a lot more migrants and individuals to the United Kingdom in order to help assist businesses fulfill their roles and goals in order to fill the workforce.
Edward, if a business is already a sponsor because they previously recruited talent from other parts of the world, do they need to apply again? And is this about extending the current sponsorship scheme to include those coming from Europe?
Yes, so I had a few companies calling me up saying, do we need to apply again? But if you already hold a sponsor license, you don't need to reapply. So that's important to note. But do keep a note of the expiry of your sponsor license. So, I mean, usually what happens is that every January, some sponsor licenses are expiring. So you need to make sure to renew that sponsor license. But certainly, yes, if you want to start transferring people from European offices, then you may want to look into exploring the possibility of holding a sponsor license going forward.
And in terms of advice or guidance for businesses that currently rely on EU migrant labour, what should these businesses do to prepare for the new immigration system? And indeed, what advice would you give them to minimize any disruption to their business?
Okay, so there's a few elements to this. The first part concerns workforce planning and workforce assessment. So, what parts of your business have a high number or high proportion of European workers, and what would these people be doing? So, if your company, has a high proportion, a particular job that is skilled, from there that you're ensuring that they're sufficiently skilled to qualify for a work permit, and then budget planning. So, budget planning is really, really difficult this year given the circumstances, because nobody knows how the labour market will unfold and what the working world will look like in the new year. But it is possible to make certain assumptions. So for jobs that are skilled, you need to be looking at a salary, making sure that it meets the minimum salary requirement for the visa, which, as I've said before, is 25,600. That also is the going rate. You can check on the gov.uk website, and there's a list of categories and salary levels to check with regarding the particular job role you're looking to recruit for. So I think that's certainly something to look at. Obviously, individuals that are here in the UK, if they are European nationals, crucially apply before the grace period finishes on the 30th of June 2021 to the EU settlement scheme. But if you are employing new employees from overseas now, then they will have to be sponsored and will have to apply for the skilled worker route.
Thank you. I think as we wrap up, Edward, what should businesses do to find out more information and make sure they're up to date about changes to the immigration system?
Yes, so employees can do a number of things to find out more about the new immigration system. Importantly, we have a lot of materials on our own website which you can refer to, and we'll be providing the link of that after. Also, employees can go to the gov.uk website, and there's a section there on hiring from the EU. This has all the information on how to become a sponsor, on how to go about recruiting migrants, but it is very simplistic. It doesn't contain the nuances that companies would need to navigate through in order to become a licensed holder. So, I think the best advice would be to get in touch, and we can then, look to liaise and hopefully provide advice with regards to how your company would like to proceed going forward.
Yes, thank you, Edward. So before I let you go, briefly, what is the one message you'd like the viewers to take away from today's discussion?
So I know it's a very busy and uncertain time, and so it's important that if you are a company and you don't have a sponsor license, and I think you seriously need to think about whether or not you require one for, if not now, but for the long term, because the workforce in the UK is changing quite significantly. So that's something to take into account. Also, I think to make sure for companies is that they are compliant and that they have workers who have the relevant visa type, and this especially concerns EU nationals. So do make sure if you have been resident here before the 30th of December 2020 that you do hold pre-settled or settled status under the settlement scheme, and just make sure that going forward you understand the criteria for sponsor license and how it works for you. So if you are looking and considering potentially obtaining a sponsor license and are looking for advice on the process, then please do not hesitate to contact us here at Sterling Law, and we'll be happy to provide advice and guidance for your company.
Thank you, Edward, and thank you everyone for watching this useful webinar. If you have any questions, please get in touch, and don't forget to subscribe to our YouTube channel and follow us on Instagram and Facebook. All links will be provided, and if you're watching it on YouTube, the links are below. Have a fantastic day, and we look forward to speaking to you again soon.
Thank you.